I'm going to share a little bit concerning contributions and the mechanisms and operations of law that exist concerning our fundamental rights and freedoms through the international covenants and the Constitution Act of Canada. So sometimes when you haven't paid your taxes or if there's a dispute concerning the amount, you're called into a tax court, the Tax Court of Canada. So this notification, this notice would be based upon the fact that the government has now called you or is attempting to call you as an individual, not a corporation, into the Tax Court of Canada. Your party has requested that I attend a court hearing on such and such date. The position of your party is that I am an officer of Canada, resident, according to the Income Tax Act, the ITA, and that as such I have received taxable income under the ITA and I am failing to perform my obligations according to said enactment. I am aware that the court that I am being called to attend is a superior court of record, and, as such, it possesses inherent jurisdiction. The Crown is seeking to have me present myself into this court as an officer under the Income Tax Act, to thereby gain jurisdiction within the strict context of the statutory side of the court. Now, when you look to the court description, it says the Tax Court of Canada is continued. The Tax Court of Canada is continued under the name of Tax Court of Canada as a superior court of record. When we look to Scurrola versus the Minister of National Revenue 2002, it states the term inherent jurisdiction is one that is commonly and not always accurately used when arguments are made with respect to the jurisdictional basis upon which a court is asked to make a particular order. The inherent jurisdiction of a superior court is derived not from any statute or rule of law, but from the very nature of the court as a superior court. And continuing on, it says in Scurrola versus the Minister of National Revenue, 2002, in Vuji versus the Queen, on page 1080, the court, as a statutory creation, does not have inherent jurisdiction. So the position of the Crown is they want to call you into court under the Income Tax Act, which is a statutory creation, and they want to only access the statutory side of the court. But since the Tax Court of Canada, as you can see, is a superior court of record, it also possesses the inherent jurisdiction. It also possesses the ability to operate the administration of justice. So, if I am forced to come to this court, I will be seeking a remedy for a constitutional violation, since this court, that the Crown is calling me into, is a court of inherent jurisdiction. The Crown is partaking of several actions which are limiting and abridging my fundamental rights and freedoms as guaranteed by the Constitution Act of Canada. I am claiming my right as protected under Section 52 to avail myself of any apparent obligation to the ITA, and I'm declaring that this enactment is of no force or effect against me for the legal reasons indicated below. This statutory instrument has limited, abridged my inalienable rights contrary to the principles of justice. When we look to the Supreme Court Justice R. versus Hape, it says, since it is a well-established principle of statutory interpretation that legislation will be presumed to conform to international law. In interpreting the scope of application of the Charter, a court should seek to ensure compliance with Canada's binding obligation under international law where the express words are capable of supporting such a construction. One final general principle bears on the resolution of the legal issue in this appeal. It is a well-established principle of statutory interpretation that legislation will be presumed to conform to international law. The presumption of conformity is based on the rule of judicial policy that, as a matter of law, courts will strive to avoid constructions of domestic law pursuant to which the state would be in violation of its international obligations. Your party is presuming that this statutory instrument, titled the Income Tax Act, conforms to international law, and by default respects the rights and freedoms enumerated in said instruments. While the fact of the matter, in truth, is that this statutory instrument, the ITA, has violated several of my fundamental rights and freedoms contrary to the principles of justice. So they create the income tax enactment, and then when you deal with the court or the justice system, they're under the presumption, they presume that the enactment, the ITA enactment, conforms to international law, and they presume that the income tax enactment is respecting your fundamental rights and freedoms, your natural rights and freedoms. And since they're presuming that this instrument is respecting your rights and freedoms, it's up to you to break that presumption. You have the responsibility. The onus, the responsibility is on you to show them it's actually stripping me of my fundamental right and freedom. Now in R versus Haynes, it says, prior to the Charter's advent, the individual really had no special means of protecting against incursions upon his or basic fundamental rights by the executive or legislative arm of the state, beyond making representations to the executive or administrative arms of the government, or petitioning and lobbying Parliament or legislators for changes in the law. Linked as they were to the concepts of parliamentary supremacy and sovereignty, there were no means at the disposal of individuals to muster court challenges aimed at invalidating legislative, executive, or administrative acts. Apart from these exceptions, the individual's means of challenging incursions on fundamental rights were extrajudicial and of a precatory nature that were neither effective nor potent. Respect for the rule of law, upon which, as W. Ivor Jennings in his text entitled The Law and the Constitution points out at page 42, that the law and the Constitution hinges the existence of public order, and it mandated compliance with directives and ordinances, even if they infringed upon individual fundamental rights and freedoms. So prior to the Charter, prior to the international covenants, law was about public order. And if these laws that they created infringed upon your fundamental rights and freedoms, you were expected to submit to these laws, and you had no operation, no availability to you to fight back. However, a primary purpose of the Charter was to change this relationship of the individual with the state or with the government and its laws by endowing or giving individuals an effective means of challenging acts of the state in courts on the ground of violation of their constitutionally protected rights and freedoms. The ITA, Income Tax Act, is seeking to render me into the designation of a class of person known as the Officer of Canada. This officer is incorporated into the federal jurisdiction unit designated Canada. This is a violation of my constitutionally protected rights under Articles 7 and 26 of the Charter of Rights and Freedoms 1982. The Constitution Act of Canada 1982, Article 7 states everyone has the right to life, liberty, and security of the person. In the court judgment from the Supreme Court, S.C. Thompson Newspaper Limited versus Canada, it states that everyone has the right to life, liberty, and security of the person, serves to underline the human element involved. Only human beings can enjoy these rights. Everyone, then, must be read in the light of the rest of the section and defined to exclude corporations and other artificial entities incapable of enjoying life, liberty, or security of the person, and include only human beings. It is my inalienable right not to have to be classed into a designation, not to play a role, or to assume the role of a juridical personality, in this case, more specifically, the designation of Officer of Canada. In the International Covenant on Civil and Political Rights, Article 16, it states everyone has the right to recognition everywhere as a person before the law. And in the citation from the Supreme Court, DeVito versus Canada, it states Canada's international obligations and relevant principles of international law are also instructive in defining the right. So in order for Canada to define the right and figure out what the right is, they need to look to Canada's international obligations. And in the International Covenant, it says you and I, as human beings, everyone, we have the right to recognition everywhere as a person before the law. And the right does not produce an obligation. We have the right to enter into recognition as the Officer of Canada, but no obligation. And if the executive powers or the legislators try to force us into recognition as this Officer of Canada under the Income Tax Act, they are violating our natural rights, they are violating our fundamental rights and freedoms. The context of Canada's international human rights obligations is, in my view, an important indica of the meaning of the full benefit of the Charter's protection. I believe that the Charter should generally be presumed to provide protection at least as great as that afforded by similar provisions in international human rights documents which Canada has ratified. I am not employed as defined within the context of the income tax enactment. To be considered employed within the enactment means that I am working as an officer of Canada for a Canadian corporation, which is not my legal standing. Income tax enactment, tax payable by persons resident in Canada. An income tax shall be paid, as required by this Act, on the taxable income for each taxation year of every person resident in Canada at any time in the year. Now here, when you would read that in general, most people would take the common term meaning of the word resident and think that they're talking about being located on the territory of Canada. But that's not what it's declaring. Here, this statement of law, this sentence here is saying that when you are resident in Canada, it says that you are incorporated, you are doing business in the company of Canada. That's what it's declaring. Resident, a person who has residence in a particular place. And residence, the place where a corporation or other enterprise does business or is registered to do business. Now, when we look to the Supreme Court in Thompson versus the Minister of National Revenue, we find the following. Residents are taxed, not Canadians, not Canadian citizens, but residents within the meaning of the Act. I feel quite confident that no Canadian court in similar circumstances would hold that such a person, in view of the provisions of our Act, is a resident and therefore liable. Your party is under the presumption, under the legal determination, that I have residence in Canada. I do not have residence in Canada. As I mentioned above, I am not employed for Canada, I am not an employee of Canada, and as such, I am not under the legal designation of officer. Income tax enactment definition. Office means the position of an individual, entitling the individual to a fixed stipend or remuneration, and includes a judicial office, the office of a minister of the Crown, the office of the member of the Senate or House of Commons of Canada, a member of the Legislative Assembly, or a member of a legislative or executive council, and any other office, the incumbent of which is elected by popular vote. So your municipalities, when you vote for your mayor and so forth, they are considered an office also under the ITA Act. And it goes on to say, and officer means a person holding such an office. So if you work in an office, then you're an officer. And employed means performing the duties of an office or employment. An employee includes officer. Employer in relation to an officer means the person from whom the officer receives officer's remuneration. Employment means the position of an individual in the service of some other person, including Her Majesty or a foreign state or sovereign, and servant or employee means a person holding such a position. Now, if this is your first being exposed to this video and you have no idea what this is saying, go back and watch my prior videos. I'm not going to waste the time trying to explain it here again. But those who have watched my other videos understand what this is saying, and I'll continue. So since I am not an officer of Canada and subsequently not employed as defined within the enactment, I have no obligation to exercise any privilege associated with the social insurance number and have no taxable income. It is only as an officer of Canada that must present or use such a card. This is why participation in the social insurance program is voluntary. According to the social insurance application form, which is a federal enactment in box 13, where it clearly states participation is voluntary. However, through the enactment, the income tax enactment, officers of Canada are forced to subscribe to the program. So income tax enactment, social insurance number, Article 231. Every individual who was resident or employed in Canada. So resident meaning incorporated, part of the corporation, working for, doing business, and being employed in Canada. At any time in a taxation year, who files a return of income under Part 1 for the year, boom, within 15 days after the individual is requested by the person to provide his social insurance number and apply to the Canadian Employment Insurance Commission in prescribed form and manner for the assignment to the individual of a social insurance number. So when you stay in the position of man or woman, the social insurance number is voluntary. Applying for it is voluntary. However, under the income tax enactment, when they designate you a resident or employed in Canada, which actually means you're an officer of Canada, they then further force you to subscribe to the social insurance number program. This is servitude. This is involuntary servitude. In the Crown's statutory instruments, it is being declared that I and my fellow men and women are being incorporated into Canadian provincial corporations and therefore are executing our residence within the corporation. When you look to the Ontario Municipal Act, it says a municipality means a geographic area whose inhabitants are incorporated. Municipality in this act, a reference to municipality, is a reference to its geographical area or to the municipal corporation as the context requires. Body corporate. The inhabitants of every municipality are incorporated as a body corporate. The City of Toronto Act, Article 125, subsection 1. The City of Toronto is hereby continued as a body corporate that is composed of its inhabitants, and municipality means a geographic area whose inhabitants are incorporated. Charter of Vancouver, City of Vancouver. The inhabitants of the area shall continue to be a corporation. So you're seeing that we're incorporated into the municipalities. These municipalities are corporations. They are corporations of Canada. Therefore, we are considered officers of Canada under the IT Act. New Brunswick Municipal Enactment. The ministers shall administer this act and may designate persons to act on his behalf. The inhabitants of the cities and towns in existence on January 1st, 1967 continue to be bodies corporate. Subsection 3. The inhabitants of a municipality created under this act are a body corporate. And again, in the Nova Scotia Municipal Act, it says every municipality subject to this act, every municipality incorporated is subject to this act, and the inhabitants of the county of Cape Breton are and continue to be a body corporate. And again, the inhabitants of the county of Queens are and continue to be a body corporate. Now, I use these examples to show you across Canada what's going on. I cannot go to each and every municipality across each and every province. I would have hundreds and hundreds and hundreds of pages full of this. But this is the operation of law. This is the mechanism of law that they're using against us. When you declare that you are resident, listen to that word, resident in the municipality, what they are actually saying is that you are incorporated into the municipality, into that company. Now, these statutory instruments are declaring that men and women are now resident in these corporations as employees, which is the mechanism, the operation of law that is being used to levy a tax. In the income tax enactment, it says tax payable by persons resident in Canada. An income tax shall be paid as required by this act on the taxable income for each taxation year of every person resident in Canada at any time in the year. And a resident is a person who has residence in a particular place, and a residence is the place where a corporation or other enterprise does business. The Canada being referred to in the income tax enactment is the corporation Canada, and not the territory or landmass. So here, when I read this again to you, an income tax shall be paid as required by this act on the taxable income for each taxation year of every person resident in Canada. They're not saying on the territory of Canada. They're saying those who are incorporated, those who are doing business, those who are operating within the business of Canada, within the Corporation of Canada. Now, when we look to the Supreme Court judgment of Canada, it says juristic federal unit. The Supreme Court of Canada has interpreted the word Canada as follows. The Supreme Court of Canada, authority of Parliament in relation to the Upper House. Further, although Section 91.1 gave the Queen the power, with the advice and consent of the Senate and the House of Commons, to alter the Constitution of Canada, except in certain expressly designated areas, it does not confer power to amend the BNA Act. The word Canada in Section 91.9 does not refer to Canada as a geographical unit, so it doesn't refer to Canada's territory unit, to the landmass, but refers to the juristic federal unit. It's referring to the corporation. In Section 91.1 of the Constitution Act of Canada, actually it's Section 91.3, this is where the Queen gave the right to create modes of taxation and systems of taxation in Canada. But the Canada that was being referred to is the Corporation of Canada, not the territory of Canada. That's why when they say that everyone who is resident in Canada shall pay an income tax on taxable income, being resident in Canada means you're incorporated, means you're part of the corporation, that juristic federal unit. Now, when you look to the officer of the Governor General, remember, in the Constitution Act of Canada, 1867, Article 9, it says the executive powers belong to the Queen. But in Article 10, it teaches us that these executive powers were transferred over to the Governor General. And now look at the designation of the Governor General. This is the officer of the Governor General. It is an enactment. Article 2. The Governor General of Canada or other chief executive officer or administrator carrying on the government of Canada on behalf and in the name of the sovereign by whatever title he is designated is a corporation sole, a company, a federal juristic unit that we are incorporated into. Subsequent to this, the Supreme Court made it clear that the designation resident, its definition must be taken from the context of the enactment. The Supreme Court of Canada in Thompson versus the Minister of National Revenue, 1946. Nationality is not an ingredient for the purpose of the Act. Residents are taxed, not Canadian citizens, but residents within the meaning of the Act. I am not resident in Canada, and I am not doing business in Canada. I do not accept to be classified or designated as an officer of Canada. I just want to share a little deeper with you concerning the judgment that I just shared with you, Thompson versus Minister of National Revenue. So the reference, the quote, was on page 220, and it actually states residents are taxed, not Canadians. So here they mean Canadian citizen, but resident within the meaning of the Act. He goes on to state, I feel quite confident that no Canadian court, so you're hearing that? Canadian courts, the Bar Association, justice system, no Canadian court in similar circumstances would hold that such a person, in view of the provision of our Act, is a resident and therefore liable. So residents are taxed, not Canadian citizens. So said the Supreme Court. Now, in the jurisprudence concerning the application of taxes as a citizen, you find that there was a court case, Canada, the National Revenue, versus Villoni, Montreal, Quebec, in 2007. Here's the docket number. You see? That's the docket number. Because you're not going to find it electronically anymore on CanLII or anywhere else because they removed the reference. They took it off of the bank. They took it out of their public bank. And in this jurisprudence, it stated that considering that the respondent, a Canadian citizen, is a person who is subject to the laws of Canada, including the Income Tax Act. So here you had a judge that was making a statement, and he said that a Canadian citizen is responsible or subject to the Income Tax Act, but you had the Supreme Court of Canada saying that it's residents, not Canadian citizens, who are responsible to the Income Tax Act, and residents within the meaning of the Act, not just the general meaning of the word residents. So when this was brought to the attention of the powers that be, magically this jurisprudence disappeared off the public bank. But you can still find it under this reference here if you wanted it physically. I am not resident in Canada. I am not doing business as an officer in Canada. I do not accept to be classified or designated as an officer of Canada. When I look to the Supreme Court of Canada, in the case Canada Life versus the CIBC, I find the following. The narrow question before us is whether or not the bank is a person resident in Canada within the meaning of Section 250 of the ITA when reference to the bank on the check is to the agency in New York. So here we have a bank that its physical location, its territorial location, the agency is located in New York, yet it's doing business in Canada. And the question before the Supreme Court is that whether this bank should be considered a person resident in Canada. Well, if its territorial location is exterior to Canada, the term resident in Canada must mean doing business in Canada. Now, residence of a corporation within the enactment itself. For the purpose of this section, every corporation carrying on business in Canada shall be deemed, look at that, shall be deemed, will be taken, to be a person resident in Canada. So you can have a corporation, such as this bank here, that is carrying on business in Canada, even though their location is exterior to Canada, their territorial location is exterior to Canada. And if that corporation is doing business in Canada, it shall be deemed to be person resident in Canada. Doesn't mean that they're on the territory or living in Canada. It means that they're part of the corporation of Canada. Their residency is in Canada. A person can carry on business, be resident in Canada, but the physical location of the corporation is located exterior to the territory of Canada, as indicated in the above-mentioned Supreme Court judgment. To suggest the federal government has territorial jurisdiction across the entire country is simply naive and misleading. The federal government's jurisdiction extends to where the BNA Act allows, and further, there would be no requirement for Section 92 of the Constitution Act of Canada 1867 if it did. When reading Section 2.1 of the Income Tax Act, the word Canada can only be referred to the body corporate. The provinces are part of the Canadian nation, insofar as the context of the word Canada is used to describe the country as a whole in relation to the rest of the countries on this planet. However, as evidence, the word Canada in the Income Tax Act is not conducive as meaning anything other than the juristic federal unit, the body corporate. In the Supreme Court of Canada citation, DeVito versus Canada, subsection 23 and 24, it says more recently in Health Services and Support, it confirmed that the Charter should be presumed to provide at least as great a level of protection as is found in the international human rights documents that Canada has ratified. And the international law inspiration for Section 6.1 of the Charter is generally considered to be Article 12 of the International Covenant on Civil and Political Rights. My fundamental rights as enumerated below are being violated through the income tax enactment and the Crown's actions. In the International Covenant on Civil and Political Rights, Article 8.2, it says no one shall be held in servitude. And in Article 16, it says everyone has the right to recognition everywhere as a person before the law. You are forcing me into recognition as a person under the income tax enactment to classify me as an officer of Canada. And in doing so, you are holding me in servitude. This is a breach of my fundamental rights and freedoms. Now, in Zinger versus the Queen, it states, thus ministers, agencies, and administrative tribunals would have to be able to justify their actions by pinpointing to specific legislative authority in the same way that any citizen would have to be prepared to show that his or her acts were lawful. It is a recognized principle of international customary law that a state may not invoke the provisions of its internal law as justification for its failure to perform its international obligations. So you can't point to the income tax enactment and claim I'm a public officer and I owe you the duty to pay a taxable income if, in doing so, you're breaching international law. You're breaching my international rights. And that's exactly what you're doing. Through the income tax enactment, your statutory instrument, you are declaring that men and women are resident in Canada, in that corporation Canada, and as such, they are officers and they can be taxed. However, international law says that they have the right to recognition as a person, not an obligation, and that you cannot hold them in servitude. So again, a citation in Nemeth versus Canada, it states that I also accept, of course, that where possible, statutes, regulations, like the income tax enactment, should be interpreted in a way which makes the provisions consistent with Canada's international treaty obligations and principles of international law. It is presumed that the legislator acts in compliance with Canada's obligation as a signatory of international treaties. So it didn't say that these legislators are operating according to international law. It says again they presume that they are operating. Well, we see that they are not. They are removing our fundamental rights and freedoms. When you look into the International Covenant on Civil and Political Rights, it states that all peoples may for their own ends freely dispose of their natural wealth and resources without prejudice to any obligations arising out of international economic cooperation based upon the principle of mutual benefit and international law. In no case may a people be deprived of its own means of subsistence. Now, further to that, in the International Covenant, it states that you will not find anything in the present covenant that can be interpreted as impairing the inherent right of all peoples to enjoy and utilize fully and freely their natural wealth and resources. There's no provisions, there's no articles of law, there's no operations of law that are available to Canada internationally to force individuals to contribute their wealth, their resources that they create through working to a society based upon the principle of mutual benefit. And the legislators, the Canadian lawmakers, are not supposed to create enactments or regulations that violate this right. So by forcing us into the role of officer through the Income Tax Act, not only do they violate our right not to be forced into recognition as a person before the law, not only are they holding us into servitude to their enactment, they are also now stripping us of our natural right that says we don't have to contribute our resources to the mutual benefit of the society. Looking back into international law, back at those same articles of law, the same operation of law is present in America. In the United States of America, they're doing the exact same thing to individuals there. Just going to jump back in and read it again. Article 1.2. All peoples may for their own ends freely dispose of their natural wealth and resources without prejudice to any obligation arising out of international economic cooperation based upon the principle of mutual benefit. So you see that? Why they're making you contribute is based upon the principle of mutual benefit. Now, once again, nothing in the present covenant shall be interpreted as impairing the inherent right of all peoples to enjoy and utilize fully and freely their natural wealth and resources. So you can use your wealth and resources that you earn and create through your employment without having to contribute based upon the principle of mutual benefit. Now, when you look at this operation of law, this mechanism coming out in America, we go to the Constitution Act of America, Section 8. It says the Congress shall have power to lay and collect taxes, duties, and excises, to pay debts, and provide for the common and general welfare of the United States. So you see what that is? It's the principle of mutual benefit, the common general welfare of the United States of America. And you have the right to claim that you are not bound in any legal way to provide for the common general welfare of the United States through contributing your natural wealth and resources that you earn and gain. International law provides me the right to freely use my wealth and resources that I earn without any obligations to society based upon the principle of mutual benefit. The Income Tax Enactment is providing and producing a measure contrary to the Constitution Act of Canada 1982 and directly against me to remove from me my wealth, my resources, without my consent, which is to be used as resources for the mutual benefit of Canada and the provinces. Now, within the Income Tax Enactment, we find this withholding mechanism. We find this power that they're using under subsection 227.11. provisions of this act requiring a person to deduct or withhold an amount in respect of taxes from amounts payable to a taxpayer are applicable to Her Majesty in right of Canada or a province. So again, every person paying at any time in a taxation year salary or wages has to deduct or withhold the prescribed amounts and remit it to the Receiver General. And where at the prescribed time the person is a prescribed person, the remittance shall be made to the account of the Receiver General at the designated financial institution. Your party has breached my fundamental rights and freedoms through this enactment. Ye have forced me into a legal recognition as an officer of Canada, to subsequently declare that I now have what is defined as taxable income under the enactment. Ye are withholding against my natural wealth and resources. Your party then has further attempted to force me to contribute to the economic, social, and cultural development of Canada and the provinces through this designation. These actions, this enactment, is aimed at the destruction of my rights and freedoms, contrary to my legal rights as brought forth in the Constitution Act Article 7 and 26 and international law, where it states, where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant, and nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. So in the present covenant, the covenant on civil and political rights, they do not have a right to place a limitation on contributions. As you saw, we have the right to decide what we're going to do with our natural wealth. And further to that, in section 47, it's stated very clearly that there's nothing in the covenant. Nothing in the covenant, permits them, you see, nothing in the present covenant shall be interpreted as impairing the right of all peoples to enjoy and utilize fully and freely their natural wealth and resources. So in section 5 there it says, you don't have the right to limit these rights and freedoms unless the covenant allows you. And here the covenant strictly says there's nothing in this covenant that can force you to make the people contribute to you guys on the principle of mutual benefit. But they still do it by creating the income tax enactment. They still do it by classifying us as officers, forcing us to use the social insurance number, and then trying to make us pay a taxation. And again, in the Supreme Court judgment, a reference to the section of Quebec, it says, simply put, the constitutional principle requires that all government action comply with the Constitution. The rule of law principle requires that all government action must comply with the law, including the Constitution. So they have the obligation to comply with the Constitution and our rights that flow through the Constitution. And here we see that we have an international right that flows into the constitutions of our countries. Yet they're creating regulations, statutes that remove these rights, contrary to the principles of fundamental justice. Now, they may not transgress its provisions, indeed. Their sole claim to exercise lawful authority rests in the powers allocated to them under the Constitution and can come from no other source. So the powers of the government, the powers that they have, actually flow from the Constitution, but yet they violate their obligations.